good afternoon and welcome. My name is Sarah Diamond and I'm the Director of Legacy Giving with the Kansas Area United Methodist Foundation. And so thank you so much for joining us this afternoon. We're happy to have you join us for our estate planning webinar. Before we get started today, I just have a few housekeeping items I want to go over with you. So since the webinar is going to be recorded today, please keep your mic muted during the presentation just to eliminate any background noise. There will be a Q&A time at the end, so if you have any questions, you can feel free to jot those down so that you have those to reference later. I want to share with you just a very brief overview of the foundation. So the foundation works with United Methodist churches, families, and organizations to provide resources, education, planning, and financial management services. The foundation also serves individuals and families by helping them give generously now and also in their estate planning. So just to help them leave a lasting legacy now and in the years to come. And now I want to introduce to you our staff. Today we have Joanna Trapp, who is our communications associate. We have Gloria Marcus, who is our finance director, and we have Dustin Petz, who is our president and CEO. And I'm going to turn it over to Dustin, who is going to introduce our speaker for today. Dustin?
Yes, thank you all so much for being here. We're grateful to partner with you and churches and other faithful United Methodists across Kansas. As Sarah said, if you have questions, you can jot them down or you can even put them into the chat. You can open up the chat window and type them in, and then we'll engage them later. I want to introduce our person who's going to be our main presenter for today. And then I'm going to offer a prayer. John Griffin serves the foundation. He actually serves other not-for-profit entities. He's an estate planner and major gift consultant through Stewardship Counseling. He got his Juris Doctorate from University of South Dakota School of Law, and after practicing law in South Dakota, he joined Stewardship Counseling and is a member of the Kansas Bar, the South Dakota Bar, the Central Kansas Planned Giving Roundtable, and National Committee on Planned Giving. Is often a speaker, and he's been working with the United Methodist Foundation for many years, and his father before him. And so we're grateful for the ministry that John provides for our ministry, helping families put their whole estate plan in order. And so we are excited to hear from you, John, today about kind of basics of planned giving and things that we need to know about as we prepare to make a difference for our family and the causes that we care about. I want to share with you a passage of scripture. I'm reading through Paul's letters, and today happened to be the one that I'm going to read for you, a short scripture passage from 2 Corinthians from chapter 9, which was the chapter I read this morning. We hear in verse 10 this: the one who supplies seed for planting and bread for eating, that is God, will supply and multiply your seed and will increase your crop, which is righteousness. You will be made rich in every way so that you can be generous in every way. Such generosity produces thanksgiving to God through us. Let us pray. Gracious God, we give you thanks for your love and your grace in our lives, for the many ways that you bless us. Yes, we're going through a challenging time and we're struggling, and even some of us have lost loved ones and friends. And yet we know that you are with us and that you will not leave us nor forsake us. God, help us to look and see the beauty and the bounty that is present in our lives and to give you thanks. We're thankful for your generosity and your gifts to us. And of all the things that you've given to us, help us to be good stewards of it while we're living. Help us to be good stewards of it as we come to the end of our lives and to plan so that we might make a difference in our families and in our community and through the life of our church. Help us to know that you bless us so that we can be a blessing. God, we give you thanks. Pour out your Spirit upon us today as we meet. In Jesus' name, amen. John, welcome. We're excited to hear you. Thank you so much.
Thank you. I didn't know we were recording this today, and as the lawyer, that means now I have to read a 20-minute disclaimer before I start my presentation. I'm kidding about that, of course. I thought I'd add just a couple of things about my background because I think it'll be reflective on the comments that I make and the advice that I give you guys going forward. Uh, um, I'd say about 90% of my practice for the last 30 years and 27 days now has been designing estate plans through somewhere around 20 different tax exempt organizations in Kansas, South Dakota, and Indiana. The largest one is, of course, the Mennonite Foundation in Goshen. Last time I checked, they were managing over $1 billion in assets. And I'd say about 10% of what I do is drafting. I sleep at night, most nights in Heston. And of course, with COVID, the Kansas Bar Association told us there was going to be an onslaught of people calling, at home, concerned about, their health and situation and not having their affairs in order. And man, they were right about that. I had 2 more calls this weekend. I have like 9 of these I'm supposed to be drafting. And my wife told me about 130 of them around the country that I'm designing for these various organizations. So I've been doing this for a long time. The biggest thing is that I found is that there's so many people that don't have any plan at all. No will, no trust, no durable powers of attorney, no living will, as they say, no nothing. I know that's not good English. I started off as an English major, but I'm trying to make a point here. 50% of your congregation has no plan. And with minorities, it's 60 to 70% has no plan. And if you don't have a plan, then the good old state of Kansas has a plan for you. And I cited the code sections in there. You can disregard those. I didn't mean that to go into your copy, but basically, if you die without a plan, you die intestate. That's what they call it. And the laws of intestate succession of the state of Kansas kick in. And never have I found that somebody, once they know what the rules are, is comfortable with those rules. They all want to do something else with their assets. But remember, 50% of your folks out there have no plan. And so the good old state of Kansas plan kicks in. If you're married and you only have a spouse, it all goes to your spouse. Okay, that's all right. If you have children and a spouse, half goes to your spouse and half goes to your kids. So let's say you own a home in your own name, or you have some marketable securities in your own name. Half go to your spouse and half go to your kids. In other states, it's different. In Iowa, for example, I grew up in Northwest Iowa, lived there a number of years. 1/3 to the spouse, 2/3 to the kids, even if you've been married 30 years. So all kinds of crazy things happen if you don't have your affairs in order. Pretty much in all first marriages, if you have a will or if you have a joint trust, it all goes to the surviving spouse first. And we look after our spouse first and kids second, but that's not necessarily what happens if you die without a plan. Okay. If I have no spouse but children, it all goes to my children. You can see the word on there, per stirpes. Some of you may know what that is. That's a Latin term. It's slapped all over us estate planning lawyers, both in Kansas and South Dakota, where I come from, use the term per stirpes. It just means by the root or by the branch. So if a child predeceases me, that child's share of any inheritance would cascade on down to their kids. And so that happens. If I don't have a spouse or children, then it goes to my parents. So if we don't have anybody in the line of descent down, no children, no grandchildren, no great-grandchildren, then it goes up to parents. And then if I don't have parents, it goes out to brothers and sisters and nieces and nephews. It goes out to 6 levels of consanguinity. And guess what? The state of Kansas says if we can't find anybody to leave it to out to that level, it goes to the state of Kansas. And who knows in Topeka what the heck they do with that. I think it's fixing potholes in Topeka itself. I'm not sure. But if you die intestate, you've lost complete control. At least in South Dakota, I'll tell you. I know none of you work up in South Dakota. This isn't a good time to be up there by the time of year to be up there, by the way. It really does look like Dustin's picture there in the Black Hills. But in South Dakota, at least it goes into an education fund, not so in Kansas. So most people, if they're exposed to that, that concept, that understanding that if you don't have a plan, all of a sudden these predetermined rules kick in, sometimes that's an incentive for them to get in front of a lawyer, and preferably an estate planning lawyer, not necessarily a general practice lawyer. Some other kind of consequences that I thought about a couple of minutes before I got on with you guys is very often younger members of your congregation that have kids, if they don't have a will or the trust, then they don't have a way legally of nominating guardians for their minor children. That's a huge deal for young folks, is who's going to raise my kids if my wife and I are killed in a common accident. And you can nominate a husband and wife. And then what I advise people is to nominate a backup husband and wife, because if the original husband and wife is guardians that you name, if either one or both of them are incapacitated, deceased, they're divorced or legally separated, that's usually the kind of the way I pair it out, then I like to go to family unit number 2. Now, not everybody agrees with me on that, and ultimately it's the client's decision, but I like a husband and wife and then a backup husband and wife. And I think I've never named 3, but there's no reason why you couldn't do that. But that carries heavy weight with a judge. And the formal way you do it, of course, is in your last will and testament. Some estate planning lawyers in Kansas, if you have a trust, those of you that know about trust, you also have a last will and testament. Some lawyers will put it in both documents, but the probate code says it's supposed to be, it needs to be in the last will and testament. So that's a big deal for young folks. So if you're having young folks that are having trouble finding the time to go see the local attorney to name guardians for minor children, that's sometimes a way of getting them off the hump and doing it. To share a story with you, I have a friend that lives in Idaho. He's a Duke Law grad, CPA, very, very skilled tax lawyer. He was telling me about a case up in Idaho where husband and wife had no plan, and they were killed in a motorcycle wreck, and they had 3 kids, and they told other folks in the community that they wanted their 3 children to be raised by their best friends and their 2 kids. And so they petitioned the court to serve as guardians. And then each of the parents, one set of parents was from South America and the other set of parents was from California. And they all 3 of them petitioned the court, a court of competent jurisdiction, and to determine, who would serve as guardian. And who do you think wins? The one that wins is the one that hires the best lawyer. Those kids are being raised in South America now. And so you completely lose track of who's going to raise your kids. That's a big deal for young married couples. And it's why I see a lot of people coming to see me. Remember that if they're having trouble taking the time to go visit a lawyer, naming guardians is a pretty big deal. And remember that idea of the husband and wife, and then maybe the backup husband and wife. A lot of lawyers that don't do estate planning all the time don't think about that either. So
if you die without a will, does some of the money go to a charitable cause?
You're one step ahead of me, Dustin, and that beats the alternative. Number 2 is you can pretty much guarantee, unless you have all of your accounts set up as payable on death or transferable on death, and you can't miss any, that there's going to be some kind of probate when you pass away. My dad was a real smart guy. He was one of those Mensa guys. He had his master's degree in education from Columbia University in New York. His PhD was from Michigan State University. He was the youngest principal in the history of the state of Michigan. He was 24 years old working on his PhD. The reason I tell you that is he called probate the Full Employment Act for us lawyers. And there's some truth to that. If there's any little glitch and we're doing a probate, remember that the lawyer and the judge, there's a 50-50 chance they went to the same law school in this state. In South Dakota, it's 100% chance. There's only one law school in South Dakota. And the judge makes sure that the lawyer gets paid first. And we're great about making mountains out of molehills. I'm not saying all lawyers do that, but it usually costs 2 to 3% of your estate to settle your estate through probate. It's significantly less if you can avoid it. If you don't have any sort of plan in place, the chances are there's going to be some kind of probate. Yes, they have simplified estate administration, but more than likely it's going to be a full-blown probate. Takes a bunch of time, costs a bunch of money. And that's number two. And then the third one is the one that Dustin was referring to. They may make a charitable gift without an estate plan, but the charity is the state of Kansas. It's not your church. It's not the Kansas Area United Methodist Foundation, or it's not some other charitable organization. So there is literally zero chance that somebody in your congregation is going to make a gift to your church if they don't have an estate plan in place. Now, that's not entirely true. The one caveat to that is it's possible that they could make your church the beneficiary of a retirement plan, an IRA or a 401k plan, or a life insurance policy. But the general rule is if they haven't even taken the time to do to do wills or a trust, they haven't thought about the rest of the stuff. And so it's unlikely that you receive anything, even though maybe they intended that you get a portion of the estate. So that's one of the other unintended consequences maybe of having no plan. So we start with that, with half the population out there having no plan. What is an estate plan? And I'm trying to keep this simple. Most folks either have a couple of wills between husband and wife. I call it the I love you plan. I love my spouse dearly. I'm going to leave my spouse everything. If my spouse predeceases me, then in some form it's going to go to my kids. If they're under 21, they get a uniform transfer to Minors Act account. If they're over the age of 21, they leave it outright. I see a lot of that kind of stuff, the simple kind of plan, but at least we have a plan in place. The technique that I find myself using a lot more than wills anymore is the revocable living trust. It's a faster, more efficient way of settling the estate. There are different ways of setting it up. The exemption from federal estate tax this year under the 2017 Tax Act passed by Congress and Donald Trump increased the exemption. This year it's $11.7 million per person. And ever since January 1st of 2010, they've allowed a couple to port, it's called portability, the first spouse's exemption to the surviving spouse. So we're at $22 million before anybody has a taxable estate. Will the new administration reduce that? I have no idea what they're going to do. I think it's a possibility, but you know, except for the uber wealthy folks, there is no estate tax, and there is no state of Kansas estate tax anymore. And as long as the Republicans control the House, the legislature in Topeka, I don't think that there will be. So, so a lot of folks can move from the will to the trust, and there's three primary advantages, as I see it, of the revocable living trust as a planning technique to have an orderly disposition of your assets to the next generation over the will. And the first one, of course, is the avoidance of probate. The Uniform Probate Code in Kansas refers to a trust as, trying to remember the exact words, as a will substitute. That's what they call it, a will substitute. But the biggest advantage of the trust is avoidance of probate. It's not enough, though, just to do the revocable trust. You got to get your property retitled into the name of the trust. And for most folks that don't have taxable estates, we do, and between husband and wife, you do one trust for both of them. It runs as long as either spouse is alive. When one spouse passes away, the trust just continues for the lifetime of the surviving spouse. And if the surviving spouse is dead, then you have your distribution to family and or to charity. But biggest advantage of the trust is avoidance of probate. The second biggest advantage to the trust, as I see it, is if you own out-of-state real estate, or a deeded timeshare, or a cabin in Colorado, or commercial real property, or oil and gas interests, anything like that outside the state of Kansas. If you have no plan, or if you have a will, there has to be two probates. There's one in the state of Kansas, and then when you finish the one in Kansas, there has to be an ancillary probate, that's what they call it, in the state where the property is located. And the out-of-state lawyers will really gouge the daylights out of the estate. So it's almost a no-brainer, even with people with not very large estates. If they've inherited some property, anticipate they're going to inherit some property. For my Mennonite clients, it's farm ground up in Nebraska. There's a lot of Mennonite farmers up there. You go up to York and hang a left about 10 minutes. That's the best farm country in Nebraska. And I say this, I'm a Methodist talking to, and my wife's Mennonite, so I feel like I can talk about both. That's where the Mennonites jumped off the train. They have an ability to do that where the best farm ground is. They raise their kids up there in Nebraska. The kids look around when they graduate from high school. Where are we going to go to school? We're going to go to school in Nebraska. Well, you got University of Nebraska, Omaha. You got the University of Nebraska. You got Creighton. You got some good schools there, but they're not Mennonite schools. And so they come down to Kansas. They go to Heston College, or they go to Bethel College or Tabor College, and they meet somebody in college, and there's more to offer down here than there is maybe up in Nebraska. I'm just make that argument. And so they stay here and they have kids, and grandma's sitting up there on the farm in Nebraska, and she can't get her husband off the tractor until he has some kind of a health problem. Cash rent the farm. They move down to Kansas. They never update their plan, and then they die. And they die with wills that were drafted in Nebraska and no trust. And so we have a probate here, and then we have another probate up in Nebraska. And I can't tell you how many times that's happened. That is the Full Employment Act for those small town Nebraska lawyers. And nobody's looking over their shoulder. So, so that's advantage number 2 to the trust. Anybody that has out-of-state real estate, any of that kind of stuff, if you have a trust, you just title the property in the name of the trust with a quit claim deed or a warranty deed, and you get it recorded in the county in the state where it's located. You don't have probate in either state. So that's advantage number 2 of the trust. Advantage number 3 is only advantage to some people. It's a more private type of a document. With a will, for a will to be effective in Kansas, it has to be filed with a court, the court of competent jurisdiction where you're domiciled, within 6 months after you die. They call it preserving the will, in order for it to have a cause and effect. And so it becomes a matter of public record. Anybody can go read it or make it a copy of it. I can tell you, in and around Heston, my Mennonite clients don't want anybody knowing their business. And when they find out that that happens, well, they just as soon move on to the trust, because the trust is all designed not to have a judge involved in the process. It doesn't have to typically be filed with the court. And again, you have that orderly disposition of assets. Maybe it takes six months, 3 months, 6 months, 9 months, but it doesn't typically take as long as a will to settle the estate. So those are the 3 primary advantages of the trust. The biggest advantage of the will is that it costs less on the front end. Now, I don't know in the small towns, I'm going to use Wichita, but to have a good estate planning lawyer, a skilled estate planning lawyer, do a couple of wills, 2 durable powers of attorney for asset management, 2 durable powers for healthcare decisions, and 2 living wills, I'm going to say $700 to $900 for the package. To do the same plan with a trust, there's a lot of variance there. I'd say between $2,000 and $5,000 for that. People that work with me first, one of the advantages, we've designed it all ahead of time so we can stay on the low end of that. So most of my stuff with my clients that I'm not drafting, that I've got some other lawyer drafting, that I'm just designing because I met them through a charity, we're in the $2,000, $2,200 range for a simple joint trust. Usually there's a couple of filing fees to get the house recorded and that kind of thing. And those, whatever out-of-pocket costs of the law firm, are passed on to the clients, but in that range. So it's about twice as expensive to do a trust on the front end, but if you're saving 1% to 3% of your entire estate on the back end, that's pretty easy math. if you ask me. So I'm doing a lot more revocable trusts. I'm taking people with no plan and we're going to the trust, or people that did wills 25 or 30 or 40 years ago to name guardians for their minor children, and we're moving them, their assets, their estate has grown, and we're moving them to the trust. It's kind of like you either pay us lawyers on the front end or you pay us on the back end. And if you pay us on the front end, it's typically going to cost less. So I do a lot more trusts and a lot of joint trusts. Now, second marriages with blended families or really large estates, the rules are different, but this is estate planning 101. This isn't grad school stuff. So we do a lot of joint trusts. If we have a larger estate, or we have a second marriage with a blended family, no prenuptial agreement, and the husband has kids from the prior and the wife has kids from the prior, they've only been married 3 or 4 years, so they say they trust each other, but they really don't. Very often then we'll do 2 separate trusts. They'll each put their own assets in their own trust. They'll consent to each other's plan, and then we'll set aside the first estate at the first death in a separate irrevocable trust for the benefit of the surviving spouse. And then at the surviving spouse's death, the predeceasing spouse's estate goes to the predeceasing spouse's kids. Surviving spouse's estate goes to the surviving spouse's kids. And that's typically when I'm doing 2 trusts now. I don't have too many clients that have estates over $22 million. So, and a lot of them are first marriages. So we're doing a lot of joint trusts. If you have somebody back in between 1987 and 1997, the exemption was frozen at $600,000. Okay. Under the 97 Taxpayer Relief Act under Bill Clinton, they started increasing the exemption, 625, 650, 675. He goes out, Bush 2 comes in, W. Bush, and he immediately jumps the exemption to $1 million. That was the Economic Growth and Tax Relief Reconciliation Act of 2001. And he started increasing the exemption. He couldn't get 60 senators to agree. So it got up to $3.5 million, and then Obama took office, and so people back then, a lot of people, if you have only $600,000 exemption, a lot of people had taxable estates. So we have a lot of old plans, either with wills or trusts, where you automatically set aside the first estate at the first death, and we don't need that kind of sophistication. We can actually simplify the plans now. So if I have a couple that have been married a long time and they have 2 wills or 2 trusts that says set it aside at the first death, well, we may take those wills and move to trusts, or if we have trusts and we've already funded them, we've retitled assets into the name of the trust, we might just say at the first death, let's just leave everything to the surviving spouse. But if I'm wrong about the exemption and the exemption goes way back down, we can always disclaim to that tax sheltered trust if we need it, so we can simplify the plan. In law school, they teach us the mechanics of how to do all this. Actually, you learn most of it when you get out, not in law school. But there's a whole nother level of the philosophy of estate planning. And for those folks that have the 2 trust plan or the 2 wills that set it aside at the first death, mechanically it may be fine, but the problem is when the husband dies, and 7 times out of 10, the husband dies first in this country, and the wife's 85 or 86 years old, and all of a sudden, all those assets that she helped him accumulate are down in some irrevocable trust that she doesn't understand anymore because she's now in the retirement home over there at Wesley Towers. It causes a lot of consternation. And so sometimes it's simpler to just say, if we know there's not going to be any estate tax, to just leave all the assets to the surviving spouse. And again, if I'm wrong, we can always disclaim down to that irrevocable trust. You got 9 months after the first death to decide as a surviving spouse whether to assimilate those assets or disclaim them down to the tax sheltered trust. So the point is, people that have a plan in place that was done a long time ago, just because of the increasing exemptions, we may be able to simplify the plan. And you just have to look at it and see. And then, I put under that heading, what is an estate plan? PODs and TODs. POD just stands for payable on death, and TOD is transferable on death. Vehicles and land, you can do transferable on death to this person or that person. Payable on death is more marketable securities, CDs, checking and savings accounts, that type of thing. But it works great And a lot of financial advisors will tell their clients this, just set up everything as POD or TOD. You don't need a will or a trust. It works great if everybody agrees to die in the right order. But if one of the kids predeceases their parent, it's right back in mom and dad's estate. Now it has to go through probate again. So I don't like probate. And I also don't like, for that reason, POD and TOD designations. Spend a little bit of money, do your trust, and avoid probate at the first death and avoid probate at the second death. In a 20 or 25 page trust document, we can cover all those what ifs if one of the kids dies out of order. That having everything set up in POD and TOD designations is what I refer to as one of the 10 most common mistakes in estate plans that I see in Kansas. And it's promoted, quite frankly, by lawyers that don't do this all the time, by accountants, and by financial advisors. I see it all the time. No disrespect if anybody, is wearing one of those hats, but I hear it all the time. So better to have a plan. Roman numeral number 3, why do I need an estate plan? Well, I mentioned that earlier. We have an orderly disposition of the assets. If we have adult children, they can go outright to the kids. If we have a child that's an alcoholic, a drug addict, a spendthrift, or developmentally disabled, we can leave their inheritance to them in a trust and protect them from those bad things that could otherwise occur if we leave it the wrong way. We can cover that what if a child predeceases. Remember that term is per stirpes. Per stirpes is down by the root or by the branch. Across is per capita or share and share alike. So if a child predeceases us and we have grandchildren that are young, you don't want to give the grandkids too much too soon. And so we can make provisions. We can set up a subtrust, an education trust for grandchildren or more remote descendants of somebody that inherits assets is young. If you don't have any provisions for that, what age are they emancipated? In Kansas, they're emancipated at age 18. And that's a real fun 6 months, and then the money's gone. I had, I don't know if any of you live in southeastern Kansas, but I had a retired judge come up to me after I did a presentation to a county bar there on estate planning. He waited till everybody left, and the next morning at 8:30 in the morning, I had to be in somewhere in Enid, Oklahoma. So I got to go drop down, take that, whatever that interstate where all the casinos are, and then keep going. I had a long drive ahead of me, and I was packing up my stuff. All the other lawyers left, and he said, John, he said, well, you were talking about the kids getting too much too soon. He said, I didn't want to share this in front of the group, but he said, that happened to me. And he said, I thought I was pretty smart about this, and I had this thing set up. So a little simple will, when the surviving spouse, the wife, passed away, it just went to their child, and we set up no, we didn't have any provision. He didn't have any provision. So at 18, he inherited his money, and it was several $100,000. And he stopped in at the lawyer's office. He said, the lawyer said, well, what are you going to do with this money? Because back then he was a lawyer and not the judge. And again, this is the judge relaying the story to me. And he said, well, where do you think I'm going? And he said, well, I'm going down to the Chevy dealership. I'm buying myself a Corvette. Exactly what he did. By the way, you know what the average number of days between when parents passed away and the decedent who gets an outright bequest before they make their first major purchase? 9 days. 9 days. And so he went down there, he bought so the lawyer said, because he stopped back with his brand new Corvette at the lawyer's office, and the lawyer said, where are you going to go? He said, well, I'm going to California. He gets a call 6 months later from this guy, and he was completely out of money, lost the car. He asked, what's that, Western Union, he asked the judge to Western Union him enough money so he could get a bus pass back to this town. I'm protecting the town in southeastern Kansas. And the judge met him at the bus stop. The kid didn't even have his shoes. And there's lots of those. I'm just sharing one of those, lots of those stories. So you don't want to give too much to kids too soon. I typically like to set up an education trust for young beneficiaries. So if I have children or grandchildren that are young, we would do one trust with separate shares. I don't call it a trust for children or trust for grandchildren, because remember, in a per stirpes distribution, we don't know who's going to wind up being the beneficiary. And I don't want to keep rewriting those provisions, same provisions over and over for children, grandchildren, great-grandchildren, great-great-grandchildren. We're not doing that. We just call it a trust for descendants. So it applies at any generational level. And I usually say income is discretionary at age 21 or 22, all income after 21 or 22. But I like to say no distribution of principal except for catastrophic illness, as we define the term in the four corners of the document, or education up until age 25. And that allows them between 18 and 25 to go get a college degree or some post-secondary education. How do I define education? Well, you need to define it in the document, because otherwise the poor trustee at the trust is going to be at loggerheads with the smart kid that knows there's a bucket of money in here and they want it to do other things with it. So you got to define your terms. So many lawyers don't do that. So how do we define the word education? I say primary, secondary, post-secondary, graduate, postgraduate, trade, or technical school. And I think that covers the gamut. Any education is better than nothing. And so what's an appropriate educational expenditure? Well, we go through and we ask them, is it books, computer, tuition, fees, room and board, travel expenses to and from? Can we buy them a used car or not? What about a semester or year abroad if they're getting college credit in the US for it? What about a voluntary service with a church-related organization or government organization? My Mennonite clients love that one. Methodists, a little more ambivalent towards that. But clearly it's educational. So do they like it or not like it? As they make decisions, we write it down. Do they have to maintain a certain grade point average after they graduate from high school? We're paying for it now. Do they have to at least be doing middle C work? What happens if they drop below? Do we give them a grace period to get it back up? What happens if they predecease the term, they die before age 25? Or if it's a large amount of money, maybe we'll do a tier distribution of principal, like a fourth, a third, or a half at 25 and the rest at age 30. So if they blow it the first time, they got a second chance. And we don't have it come out automatically at 25. You have to say in the document, you need to say, upon written request. So if they're involved in a lawsuit or a divorce, they ran over, and my example is Brad Postotnik's grandchild on a crosswalk in Wichita, 100% chance there's going to be a lawsuit there. And if you don't have it resolved, leave it in the trust. It's an irrevocable trust. All good estate planning lawyers will add a spendthrift clause to it. And so those assets are protected. Just don't have it come out automatically. The kid has to, or grandchild has to request it in writing. That's how you protect those assets. And if they die in the interim, it cascades on down to their kids under the same terms and conditions. If they don't have any kids, it goes to their siblings. If they don't have any siblings and we're at the grandchild's level, it comes back up and over to the other children and down. That's a pure per stirpital distribution. All right, so maybe that's estate planning 202. But that's the kind of stuff that you can cover in a good estate plan. And it's so important, and it makes for much better orderly transition of the assets, so the beneficiary isn't getting too much too soon. If when they receive their inheritance, they're 35 or 40 years old, well, in my opinion, you don't teach an old dog new tricks past age 30 so they can get it outright. But we cover that if somebody dies out of order, if we have young beneficiaries. Compare that to they get it at age 18 or 21. Roman numeral C at the bottom of the first page there, drug or alcohol issues. I come across those all the time. Obviously the easy answer is to disinherit that child, but I don't get very many parents to do that. Well, you don't want to pour gas on a fire. You leave them a big inheritance outright. That's going to exacerbate the problem. You guys have more of those and have dealt with more of those kind of things in families than I ever will, and you're probably better at handling it than I am. But in an estate plan, if we're not going to disinherit the kid, we need to leave it to them in a trust that runs typically for their lifetime. And then you set it up in such a manner that some independent trustee, and you can do this through a will or a trust. You can create this sub-trust under a will or a last will and testament or a revocable trust. And we set it up so it runs for their lifetime, and you have somebody else typically serving as trustee, doling out income and principal, but you'll write some language in there that requires them to submit periodically and unexpectedly to drug or alcohol tests. And if they ever fail, very often we'll write a provision in there, the trustee is not allowed to make any more distributions for the rest of the calendar year. Irrevocable trusts are always on the calendar year. And so you don't become, as a parent, an enabler after you die. So if you have a disability, if you have a child or a grandchild that is on or will be on or likely will be on SSI, SSDI, or Medicaid, if you leave them their inheritance outright, or you leave it in what I just described, the support trust for their health, education, maintenance, and support, what happens? The state of Kansas will say it's an available resource because it's for their support and require them to spend their inheritance down to about $2,000 index for inflation, and then they have to try to reapply to get back on the program. So what we can do for that kind of person is we can leave their inheritance to them in what's called a supplemental needs trust or a special needs trust, where the trustee can make distributions out of the trust, but only for things that are not covered by a government entitlement program for which they're eligible to receive benefits. So they don't have to go through a spend down. And the very best estate planning lawyers will put it in every one of their trust documents or their wills, because we never know if mom and dad become incapacitated and then we have a kid that's in a car wreck that has brain damage that was otherwise going to get their inheritance outright. Well, we can now set up this special needs trust for them so those assets are protected. Well, Dustin, everybody's at least still awake.
Yeah, they're all awake, and we got time to wait to ask their questions.
Act 5, Scene 5 of Macbeth. A tale told by an idiot, and a lot of sound and fury signifying nothing.
This is super helpful, John. And I appreciate the, can you, I'm going to ask a question, you can elaborate and then we can move on, but you just said that it might be advisable to have such a special needs trust for, even if you don't know if a child might have a problem or a person might have a problem. If they don't have a concern, do they then have those assets locked away that they couldn't ever get to it? So, or if they didn't have a need and they're fine, could they get access to the rest of the trust, or is it just like a annuity kind of thing for the rest of their lives?
Yeah. So what you do is you leave it in the trustee's discretion, and whoever the trustee is or the executor can determine at that time, which is at death, whether or not we need to set that up or not.
Okay.
And you make it available, and it's just an option in the discretion of the trustee. So that's how you typically write it. How am I doing on time? I wasn't really paying a whole lot. Once I start talking, I kind of forget. Do I have much time left or not? Give me a.
Yeah. I think you have about 20 minutes.
All right. Let me keep going then. I'm over on my page 2 of my outline, and I'm looking at the master and Roman numeral number 4, how to get started creating an estate plan. Well, Dustin would like, and I'm sure Sarah would like, and Joanna, if you help them identify people that need this kind of help, because I'm the best kept secret with most of these charitable organizations, and that includes Emporia State University Foundation, Washburn University Foundation, Black Hill State University Foundation up in South Dakota. If you have people that need some help getting their affairs in order, I work one day a month for the foundation. The problem for them is I can't do very many of these every year. So we want quality people, hopefully people that are philanthropic or will at least entertain that idea, although that is never my primary focus. My focus is on mom and dad, if we have husband and wife, and then the survivor of mom and dad, and then the kids or more remote descendants. They want to do something charitable, we'll figure out the most efficient way to do it. But it takes me 4 or 5 meetings. Actually, Dustin's got me in front of a couple, two couples that have, pretty significant resources, and they want to do more sophisticated planning, and so that takes more meetings. So but if you have somebody or somebody in your congregation that could use this kind of service, I can pretty much guarantee you we'll save money in the drafting lawyer's office, because we'll work out all those details. By the time I get done, we're going to have a 10 or 15 page outline in nauseating detail, so that the drafting lawyer can just go back to their office and start drafting the documents and don't have to ask them a whole bunch of questions. So that's certainly one thing. For people that just want to find a lawyer that does estate planning, I'm on Romans 4b. Martindale Hubbell, that's in every law library in every county. That's a list of all the lawyers in private practice, at least the ones in bigger firms. And you're looking for somebody that does pretty much estate planning. Very often they're also a CPA. Some of them will have an LLM, which is a master's degree in tax law. You won't find that in the small towns, but certainly in, you know, the more metropolitan areas, you'll find those people. Those tend to be pretty much exclusively estate planning lawyers, and you get a better document from them than you do from the general practice lawyer or the criminal defense lawyer, you know, that's hanging out at the courthouse all day. And no disrespect to them, and I don't mean that, but I use it if I was to use a medical analogy. If you need brain surgery, you should go to a brain surgeon, not to your general practice doctor. The same thing's true with lawyers. Those of us that don't have a life, we sit around and we work on our, commiserate over our wills and our trusts, and we're constantly tinkering with our documents. And we go to another seminar and we come back and we update and change. That's who you want drafting your documents. And it costs less in the long run, typically, because they know what they're doing. So if you're asking for anything special, the good estate planning lawyers have pretty much seen and heard everything if they've been doing it for any length of time. The other way, the less sophisticated way, I would go to the Register of Deeds in any county seat. They're going to know one or two lawyers that are doing most of the filing of the deeds on real estate to transfer them to a trust. Those tend to be more estate planning lawyers. So that's a less sophisticated way. If you can find somebody that's a fellow in ACTEC, that's American College of Trust and Estate Counsel. They ask you to join that. So they really research your background and stuff. I'm not a fellow in ACTEC. But if you have somebody that is, that's not just something you sign up for. I'm still a member of the South Dakota Trial Lawyers Association. I haven't seen the inside of a courtroom in 30 years, but I'm still a member, and that doesn't carry any weight. If you're a fellow in ACTEC, they've asked you to join. They've talked to other lawyers in your community, and all of them agree that, you know, you hold yourself out as an estate planning specialist. So those are ways of finding a lawyer. Obviously, word of mouth and referrals. If you ask around enough, the same names are going to kind of pop up because they tend to do more business work and estate planning work. Top 7 questions asked about trust. What are revocable trusts? Well, we talked about, I guess, generally what they are. That's a living trust, a loving trust. A loving trust is just a trademark name. A couple of lawyers out of Colorado came up with a term. They weren't very good estate planning lawyers, but they were great marketers. And so they sold this package to all over the country and retired. But a revocable trust, a living trust, that's all the same thing. It's just a way of transferring assets to the next generation and hopefully avoiding probate on it. And revocable means revocable. The creator of the trust, referred to as the grantor or trustor or settlor. Different lawyers use different terminology for the same thing. They always retain the right in a revocable trust, typically on the first page, to alter, amend, revoke, terminate, change, or modify the trust. And so if they want to make changes in the future, to change a trust, you do an amendment. A revocable trust, you just do an amendment. To change a will, you just do a codicil. But other than that, it's basically the same thing. Inter vivos, there under Romans 5b or 5a2. Inter vivos just means created during the lifetime. It's just a Latin term. It means during the lifetime. So an inter vivos revocable living trust, sometimes they're referred to as an inter vivos trust. It just means you created it during your lifetime. Testamentary means created at death. So inter vivos is lifetime. So that subtrust, that education trust I was talking about, the special needs trust, or a lifetime trust for an alcoholic or a drug addict, that type of thing, those are typically funded at death, at the surviving spouse's death. And those are typically irrevocable trusts. You don't ever do anything irrevocable except for tax reasons, usually to protect it from estate tax or to protect the assets from third-party divorces, creditors, or somebody using a child using or a grandchild using the money for nefarious things, back to the drug and alcohol stuff. So there's a lot of confusion about revocable versus irrevocable. Most joint trusts are revocable, and then after one spouse passes away, we usually leave them revocable so the surviving spouse can make changes to the plan as they deem appropriate. But you could make it irrevocable at the first death. You make it irrevocable, you have certainty as to the distribution, but then the surviving spouse loses flexibility to make changes if changes are necessary prior to the surviving spouse's death. Can you change an irrevocable trust? Under the Kansas Uniform Trust Code, you can, under limited circumstances. That's kind of grad school estate planning, so I'm not going to focus on that. But people are shocked to hear that, yes, you can change an irrevocable trust under certain circumstances. When I set up a revocable trust, do I lose control of my assets? No, you retain control because you're your own trustee. So you're the grantor, you're the creator of the trust, grantor, settlor, trustor, and you're also the manager of the trust. And we call the managers of the trust the trustees. So if I'm a single person, I'm going to be my own trustee typically. If I'm married, my husband and wife would serve as co-trustees. If one of them becomes incapacitated or passes away, the non-incapacitated or surviving spouse would serve as sole trustee. And then, you have to decide who would serve as successor trustee after that. Sometimes we'll have children serve. Sometimes we'll have a bank trust department serve. Sometimes we'll have children and a bank trust department as co. I do not like multiple children together. I don't like 2 or 3 people as co-trustees because groupthink is a real fiasco. And when you try to do anything, you've got to, everybody's got to sign off on it. So you got to fax it all around the countryside. I'd rather name somebody, put them on the hot seat, let them serve. They need to have 4 criteria. These are ones I've developed personally over all these years. As successor trustee, it's got to be somebody you trust to manage your business assets. Sometimes we have friends in low places, the old Garth Brooks song. Great friends, but not people we want managing our business affairs. So number 1 is trust. Number 2, they have to have time or be willing to make time. Number 3 is logistics. It sure helps if they live reasonably close by. And number 4 is the late Kenny Rogers song, The Gambler. As a successor trustee, you got to know when to serve. You got to know when to walk away, and you got to know when to run away as trustee. If you're getting Monday morning quarterbacked by your siblings, resign as trustee and let it go to somebody else. And I always name a bank trust department at least last. They'll always be there. They won't resign. They won't predecease, and they don't act in an incapacitated fashion. I've had a lot more problems with individuals serving as trustee than a bank. So those are my criteria. And then I rely on family, mom and dad, to tell me, what the appropriate ordering is. So, but you don't lose control of your assets. They're in the trust, and to the extent they generate income, it just flows on out. How do I set up a revocable trust? Well, first you have to design it, obviously, then you have to get it drafted, then you have to execute the document, and then maybe most importantly, you've got to get your assets titled into the name of the trust or have beneficiary designations on them. We could do a whole different session on that. Usually the drafting lawyer will give you written instructions called a trust funding letter or trust funding memo the day you execute your documents and tell you how to transfer most of them into the trust. If you have C Corp or S Corp or real estate, generally the lawyer will help with that. Most of the rest of the stuff, or oil and gas interests, generally you'll give written instructions how you transfer checking savings and Edward Jones accounts and that kind of stuff to your trust, and vehicles down at the courthouse, that type of thing. Can I be my own trustee? Absolutely. Most people serve as their own trustee. You can always resign as trustee. I've had people say, I'm still capacitated, but I want my son or my daughter that lives here in town to serve as trustee, so I'm just going to resign to the next trustee. But most times people serve as trustee as long as they can as their own trust. We talked about those criteria with the successor trustee, those 4 criteria. And then again, I like a corporate trustee because they won't resign, they won't predecease, and they don't act in an incapacitated fashion. And no, the bank trust department doesn't get paid 1 red cent until they ever actually step in and serve. Being named, they don't receive anything. They have to actually serve as trustee. So how much income does a trust generate? Well, it doesn't make any difference. Whatever income the trust generates just flows through to the grantor of the trust, because it's a revocable trust, and the grantor trust rules apply, section 671 through 679 of the Internal Revenue Code. So to the extent I have income from an asset that's owned by my trust, it just flows through onto my own 1040. It's that simple. What about a separate tax ID number for a revocable trust? No, your tax ID number is your Social Security number. If it's between husband and wife, it's one of your social security numbers. And when one spouse dies, then it's the tax ID number is the social security number of the surviving spouse. You don't have to get a separate tax ID number until the surviving spouse passes away. And then the successor trustee would do that, maybe with the help of counsel or an accountant. It's not that difficult to do. You know, you can fill out Form SS4 on irs.gov. You can call them if you're willing to listen to a little elevator music. It's not hard to get an EIN number, but the revocable trust becomes irrevocable when you die. So that's when you get a separate tax ID number. Pushing ahead over here to the next page, primary advantage of the revocable trust. We talked about that. I'm going to skip over that. Are trustees' fees high? I get a lot of questions about that. You know, what the good trust document will say is an individual is entitled to reasonable compensation for their services commensurate with their ability, but they can't charge more than a bank trust department would charge in the same geographic area. It'll say something like that. And all banks then have what's called a published schedule of fees. And, you know, I'm going to be a little bit generic here. I'll say up to the first million, it's usually about 1% of what they manage. And then it's a declining scale after that. Some financial institutions, you know, the Edward Jones and BC Christopher, their rates tend to be a little bit higher, but most banks are around 1%. You'll find a few of them at 85 basis points, but they all have a published schedule of fees. And so if you want to know and you're comparing two different banks, it can't be any bank, it has to be a bank with trust powers or a trust department, but I'd ask them for a published schedule of fees. And if they won't send it to you, because they all have them, that means they know their rates higher and you're forum shopping and they want you to come in and explain to you why their rates are higher. And all else being equal, I'd go with one that was less expensive. And bank trust officers are a little bit like development officers. They're here one day and gone the next. And so you don't name a bank just because of the trust officers there, because they may not be there, you know, 6 months or a year or 5 years down the road. So 8 most common mistakes in estate plans. I think I'm going to skip over that. You know, if we do this again, maybe we talk about that in the interest of time. One of the things that I did want to touch on, though, was on H, since you guys have, most of you have church affiliations or charitable affiliations. Roman numeral 6H in my master. I assume that's over on the other one, too. How do we incorporate a charitable gift into the estate plan after we've taken care of mom and dad and the kids and the grandkids and all that? You know, there are better assets to leave to charity at death. And typically the best asset, bar none, if you got it, to leave to charity at death, you can write this in stone. This has been ever since I started doing this on January 1st of 1991, it's retirement plan assets, are referred generally as to in the Internal Revenue Code as IRD, income and respected decedent. The most common type of IRD are retirement plans. Why? Because if you leave retirement plans, IRAs, and 401k plans to your kids, they got to pay ordinary income tax on it, and they have to take a distribution by December 31st of the first anniversary of your death. And under this Secure Act of 2019, this latest tax act, unless you're an eligible designated beneficiary. So if you're an adult child over the age of 18, you got to pull it out over 10 years now. It used to be the child on an inherited IRA would get a life expectancy payout. And my dad, it was the only asset I got from my dad was a piece of a retirement plan. And so I don't remember what my remaining life expectancy was at the time of his death, but he died before January 1st of 2020. And so I'm grandfathered. I get a life expectancy payout, and it's a reduced by one calculation under the single life table, 1/20th, 1/19th, 1/18th, 1/17, and it goes on down. That never changes. But now adult beneficiaries, kids, they have to pull it all out over 10 years. Now they can wait till the 10th year to pull it out. But what does that do? It drives them up into a real high tax bracket, and they don't get life expectancy payouts. So if you have people in your congregation or at your charity that have an interest in making a gift to charity at death, the best asset to give away to charity is retirement plans. Because guess what? You guys are tax exempt. you don't have to pay income tax on it. So not only did they defer the income tax in the retirement plan, they completely avoid it by giving it to charity. And there's other types of IRD. That's for another discussion, maybe another day. But that certainly is the best asset. During lifetime, it depends. If you don't, oh, how would I describe that? If you don't itemize your charitable deductions and you've reached your required beginning date, that IRA charitable rollover, taking part of the RMD and giving it directly to charity is probably the best way to go. You can give cash gifts now, whether you're if you're a non-itemizer. In 2021, it's now $600 for a joint return, if you're an itemizer, it's 100% of your AGI if you're making a cash gift. If it's during your lifetime and it's long-term capital gain property and you do itemize, that's probably the best asset if you're making a significant gift to charity. If we can get over the 24,000 and change standard deduction, because you get to deduct the full fair market value, not your cost basis. So the rules are a little more garbled during lifetime, but at death, it's always retirement plan assets. Another thing that I like a lot, if you have clients that are farmers, I do 1 or 2 or 3 of these a year, and usually they're pretty good size. You have somebody decided they're not going to farm anymore. They don't have a kid that's going to come in and farm, and they got a whole bunch of depreciated farm machinery laying around there. Instead of selling it themselves and having to pay the recapture tax, the recapture of the depreciation, because they've taken an accelerated form of depreciation on that tractor, combine, whatever, we can put it into a charitable remainder trust. The charitable remainder trust can sell it and avoid the gain on the sale, and it provides a nice income stream for husband and wife as long as they're alive. Again, I could talk for a couple hours just about charitable remainder trust, but I know Dustin is excited about that because I think last year, wasn't it, we've done a couple of those with depreciated farm machinery. I think one of them was 1.3 million and some pretty substantial ones. So, and then the other thing, I would go to this sheet. I don't know if, yeah.
Page 4.
This one here. You know, a lot of people, given the opportunity, will make a community foundation or a religious foundation at least the initial receptacle of their charitable gift. Why? Oh, okay. Why? Well, the reason is that they can change their mind about the charities they want to support without having to come back to us silk stocking lawyers for redrafting. If we make individual charities the receptacle of a charitable gift, and we change our mind about the charity, the percentage distribution between charities, the purpose for which it goes to a charity, every time we do it, we got to hot foot it back to the lawyer's office for redrafting. We have to do a codicil, do a will, or an amendment to our trust. But if you make the foundation the receptacle, well, they can just go back and talk to Destin or whoever the executive director is, maybe it's Sarah, and revise their memorandum of understanding. That doesn't mean that the church doesn't get a pass-through gift, because you can write that into that donor advised memorandum. So you make the initial gift to the foundation, and if they want it all to just pass through to your church, Dustin will cut them a check. If they want some of it to go through directly to the church, but they have 2 or 3 other organizations maybe that they want to support, well, we can keep that in endowment and distribute 4 to 5% of the value every year to those individual charities. Or you can hold it for 10 years and then pay it all out. I've done that before. A thing I learned from the Mennonites that I passed on to my Methodist clients is a lot of times folks want to lock in 80% of maybe the annual distribution of an endowed fund, but they want their kids to advise on 10 or 20% of it. That teaches the kids to be philanthropic with mom and dad's money. And that's that's been very successful in the Mennonite communities, teaching philanthropy to the next generation without the kids having to dole out their own money. That has worked. So I did this for you. Obviously, you can go directly to individual charities, but I'm telling you, most people, once exposed to the concept, will at least make the initial stop of that charitable gift at the second death some sort of community or religious foundation. And there's quite a few community foundations. There's up to 86, 87, I think now, community foundations in Kansas. There aren't 86 or 87 successful ones, but there's a lot of them around. But the Methodist Foundation has professional money managers. I don't know, where are you guys at? 60, 70, 80 million bucks or so, Dustin?
Yeah, 71.
Yeah, so I was in the range. So they got professional money managers and they do a good job. But the point is that people may want to just pass it through. They may want to use Dustin and the foundation just so that they can make changes without having to pay for an amendment to their trust or a codicil to their will. So it's certainly a viable technique. I'm going to close. I'm going to do this very quickly because I know there might be some questions coming up, or hopefully there are. My very last page, I stuck this in at the end. I was thinking about it last night. 11 observations from 30 years in the trenches. You can write this stuff in stone. I was at Sterling College one day and I had a break between appointments and I just started writing these things down. These are absolutes. And we talked about this, at least 50% of the adult population have no estate plan. No estate plan, chances are no charitable gift. I told you there's ways you can do it by naming charity a beneficiary, but it just doesn't happen unless people have their affairs in order. Most people that do have a will or trust need to have it reviewed and updated. They may think it's a good plan. It may have been drafted by a lawyer that's not very skilled, and there's problems, mistakes, errors. Things have changed with regard to the family. Things have changed with regard to who they want to serve as executor or personal representative or trustee. So the estate may have grown or shrunk over time. You know, you just don't know. Kids that are in good marriages or bad marriages. It's just constantly evolving. And every 5 years, you want to always update the durable power of attorney for healthcare and the living will, because the doctors start giving them less weight in Kansas after 5 years. Sure, that's what you want to do 8, 10, 15 years ago, but is that what you want to do now? You still want us to be able to turn the machinery off, you know, type of thing. So every 3 to 5 years or anytime there's a major change in circumstance, you need to get out your document and read it. And if you don't remember what it says, you need to get in front of somebody that can read it and tell you what it says and offer some suggestions for modifications. Only approximately 8% of adults have a charitable component in their estate plan. So those that do have a plan, only 8% of them have a charitable gift. And that means that Dustin and I and everybody else that does development work hasn't done a good enough job talking to folks about that. There's not enough old Johns around doing it. I'd say, because of who I'm picking a lot of the low-hanging fruit, I'd say my track record is about 90% of the people I meet with are making some kind of charitable gift, but they're board members at these foundations, or, you know, they've already indicated they wanted to leave some kind of a legacy. If you help a married couple, I'm on number 5, look after each other and their children or grandchildren, they'll consider a charitable gift, but you've got to provide the service first. When I'm out in Western Kansas, those old grizzled old ranchers and farmers aren't coming in to see me to make a charitable gift. They're coming in to see me because they had one kid to stay home and farm with them, and they have 2 of them that went off to K-State or KU, got bedazzled by the city lights, and they're not coming back. And how do you protect the child that stayed home to farm with you and still treat all 3 kids fairly? And when you help them figure out that kind of stuff, then the defense mechanisms come down, and they're much more inclined to make a charitable add a charitable component to their plan. So you got to provide the service first. Number 6, once people commit to a charitable gift at death, almost all of them will do a percentage instead of a dollar amount. Dollar amount is called a specific pecuniary bequest. Almost everybody will do a percentage because they don't know whether their estate's going to shrink or grow, and they want it to be proportionate to what the kids receive. Remember, I said most people make the gift at the second death. They won't do it at the first death. They'll do a percentage, and they'll run it through some sort of community or religious foundation. It's just, you know, time. I can't tell you how many hundreds and hundreds and hundreds of times I've done that over 30 years. Yeah, that's number 8. Those who decide to make a testamentary bequest at death will support at least 2 to 3 different charities. I see that all the time. Once they decide to do it, it's not just Bethel College, much to the chagrin of Bethel College. They want to support Showalter Villa. They want to support their church. They want to support Bethel College, but it's not usually one. Usually it's 2 to 3 charities. And those people that are very philanthropic, I always suggest support whoever you want to during your lifetime, but pare it down and have a real impact on 2 or 3 when you pass away. I'm a big believer in that. To the extent possible, most people will use retirement plan assets to make the charitable gift. We talked about that. And largest charitable gift comes at death. Even if we don't have an estate tax, I thought when the exemption went to $1 million, my job was done. And now it's at 11.7, and I'm the busiest I've ever been in my life. People aren't making gifts to charity because of taxes. They're making gifts to charity because they want to support those charitable organizations. And the little incentive to put them over the hump so they can explain it to the kids is we're going to leave assets to charity that you kids would have to pay income tax on anyway. All right.
John, can I
estate planning 101.
Let's start off with a couple of questions, and then we'll see what Joanne has received from the chat. One of them is you said the IRD assets, these retirement assets. Do you put as the beneficiary of those the foundation or the charitable cause, or do you put it as the trust, and then the trust manages making distribution to fulfill a tithe of your estate? Does that make sense?
Yeah, the estate planning 101 answer, Dustin, is you can do both. I could do about a 20-minute dissertation on the advantages of making your trust the beneficiary versus naming charity and then kids. There's advantages and disadvantages to each, but you can do both. Most of my clients that have a revocable trust will do the percentage gift at the second death, and we direct the trustee to use retirement plan assets first to satisfy the charitable gift. I don't want to give appreciated assets held long-term to charity if I have retirement plan assets, because if this is my basis and this is fair market value on appreciated stocks or mutual funds, under section 1014B, you got 100% step up in basis to fair market value. I want to leave those assets to the kids, because if they sell them right away, they don't have to pay any tax on them. But if they inherit a retirement plan, every single dollar they pull out, they got to pay ordinary income tax on. So I invented, developed, drafted, however you want, along with a friend of mine in the Pulcinelli firm in Kansas City, some language that all of my estate planning cronies use, and I do too, that directs the trustee to use retirement plan assets first to satisfy any charitable gift. And that way, you're not trying to figure out what the retirement plan is doing over time, because what happens with retirement plans? They're tied to the market typically, and they're either growing or shrinking over time, depending on market influences and required minimum distributions if we have to take our minimum distributions. And you're never going to hit the right amount for charity on the head unless you're watching it at least annually. And as folks get older, they get tired of that. Make the trust the beneficiary, everything flows through the trust. And then with that percentage gift, we use retirement plan assets to satisfy the charitable gift. Then you don't worry about it. It's a percentage of the estate.
Nice. We have a question that comes from the group. It's this. What are the options to close out a supplemental needs trust after the death of the person the trust has benefited?
All right. So before law school, my answer would have been, I don't know. After law school, the answer is, well, it depends. It depends on what type of special needs trust it is. If it's a third-party special needs trust, so if it was created by mom and dad for a child or a grandchild, that's called a third-party special needs trust because the money comes from the third party, mom and dad. As opposed to, let's say I'm an adult, I'm 25 years old, and I'm driving down the road, and those crosswalks for the, where those things are called for those cross deals for the train don't come down, and I run into the side of a train. I was involved in this on the back end, $2 million settlement, and this gal survived, but she had brain damage. So for 2 years, she was on Medicaid here in Kansas. And so we went to court, and the judge allowed her, or us on her behalf, because she'd earned that money by being in the wreck, to set up a first party, or what's called a self-settled special needs trust. So if I have a self-settled special needs trust, that has to have a provision in there with a Medicaid payback. So you have to pay back whatever she used up over those years back to the state of Kansas. But money that originates with mom and dad or grandma and grandpa, that's a third-party special needs trust. You don't have to have a Medicaid payback provision when that special child passes away. Whatever's left, the remaining income and principal, can be distributed to family, other family members, or to charity, or some portion to each. but it does not have to be paid back to the state of Kansas. So it depends on if it's a first party or third party special needs trust.
Thank you. Are there other questions?
Oh, and one other thing on special needs trust, I all the time set these up. They're not typically a charitable trust, but if we have one child, or maybe we have two kids and the other one got plenty, when that special child passes away, very often folks will have some of that money go back to the sponsoring organization that looked after them, like Starkey in Wichita, or to their church, or to some other charitable organization. So those are actually trusts where you can kind of kill two birds with one stone. You protect that child, you provide discretionary distributions for things not covered by a government program, but when they pass away, it goes wherever mom and dad or grandma and grandpa want it to go.
Nice. Let me kind of just, and John, you correct me if I get this incorrect, but the process that we do with John, so if you're interested, this presentation is to help you learn some pieces and to have information about estate planning as a whole. But we do offer this ministry and this service through the foundation with our United Methodist people. That if you'd be interested in engaging us about having John participate, and as he described earlier, he works with families and does the architectural work to set up the program and the process, but he doesn't actually write the documents. So then a local drafting lawyer would be the one who would actually do that. He would be in cooperation and communication with them. And so provides that service on behalf of the foundation, has for many years, and becomes the kind of a third party entity to do that well, and has your interest at heart. And you're not required to use the United Methodist Foundation as the charitable beneficiary if you have a charitable component, but we would love to be a part of that with you. It's a ministry and a service that we provide to our faithful United Methodists across Kansas.
And if a member of your congregation wants you to sit in on it, I got no problem with that. It's all the more the merrier. I got the old Al Gore syndrome. I figure I'm the smartest guy in the room, only when it comes to estate planning, by the way. But it's a great way to learn. I know Dustin sat in on a few of these early on, and it was a bit of an eye-opening experience, all the things that we cover in a plan like that. And it's the best way actually to learn it is to actually see it and see how we do this. It's one thing to go to seminars and hear it, but it's another thing when you're in the trenches actually doing this. It's much more real.
Some of the families that have worked with us have they've given a gift to the foundation at the time of death, and like John said, some of the money will go pass through. Often a bulk of it will be retained with the foundation and then become an annual distribution that we send to the church or the college or retirement community or other kinds of things on behalf of that faithful donor. I got one more question that popped up. So here you go, John. How would you recommend dealing with a second home in a desirable location that several relatives might love to inherit in tandem with cash and other resources so that those relatives are treated equally or fairly?
Well, probably the best way to manage that is to put it in an LLC or a family limited partnership. And then, you have three managed. It can either a family limited partnership or an LLC can either be member managed or manager managed. And you can put one person in charge, or you could have all three of them kind of be in charge. My concern with that is that I own a second home up in the Black Hills of South Dakota, and they get kind of expensive, and you never know when somebody's tinkering with your place up there and that kind of thing. And what kids think they want now very often changes when all of a sudden they have to pay a half or a third of that property tax every year, and you got to put a new roof on it and this and that and the other thing. So I would be more inclined to, unless, everybody was adamant about it, I'd be more inclined to just divide the estate between the 2 or 3 kids and let them decide along with the trustee or the executor if one of them wants it or if they both want it. If they both want it, you could deed it to them as undivided interests as either joint tenants with right of survivorship or as tenants in common. And the difference between that is if I give it to them as tenants in common, they can transfer their undivided interest down to their kids. But I don't know that I want to spend the time and the effort to create an LLC and all that other kind of stuff if at the end of the day, and we never know when that's going to be, when mom and dad pass away, that one of the kids really has moved on and maybe they bought their own place. So I don't like to, I'd rather have the flexibility of it. They depend on the age of the owners of the property and how adamant the kids were about sharing it, how well they got along, those kinds of things. Sometimes a kid may say, well, I'd rather just have money. So we add some precatory, or precatory just means advisory language. This child gets this house, but we're going to give, whatever the fair market value is of that vacation home, we're going to give that to the other child. And so they can get a place either right next to it or they can get a place somewhere else. I hate to lock it down if it doesn't need to be locked down because that has more flexibility. So I would be pretty cautious about that. They'd have to be pretty adamant about what they were going to do. I'd rather, the similar thing is I see the grizzled old farmer or rancher, my in-laws farm, so I'm talking about them, but my father-in-law came to me and he has 3 kids and he said, I want black acre, green acre, and red acre to go here. I want blue acre and white acre to go here. And I want pink and yellow acre to go here. And I said, why do you want to do that? He said, I've been sitting on my tractor for all these years and I figured out this is the most equal that I can make it. And I said, well, the problem with that is what happens if you have to go to the retirement home and your agent, or if you have a trust, your trustee has to sell one of those quarters of ground or one of those 80s. Well, if it's one of your kids, they're not going to sell their own. They're going to sell one of their siblings. 100% chance for a lawsuit there. So don't do that. Plus, with these new combines, you can measure every square yard that they're producing. Every square yard. So you can never find 2 pieces of ground that are exactly the same. You can't do it anymore. And so unless there's an overarching reason to do it, just say, my estate is divided equally between my kids. And then you figure it out because one kid may want land and another kid may want the land to be sold. Remember, basis gets stepped up, so there's no capital gains tax at death, and so he can sell it and the kid can get the property. But when you start dictating ahead of time more than you have to, and sometimes there's a good reason to do that, but typically not. And when I explained that to him, I was like, oh, well, yeah. None of my kids are farming. I don't know why I'm beating myself over the head and these different kids get different things. Or you can just have some advisory language to the extent possible. If I own the southeast half of the north quarter of section blah, 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 I want that to go to this child because we carved out 5 acres there for him and I'd like him to get the rest of the quarter as long as we can still do it equally between our kids. That's the most important thing, is that at the end of the day, everybody feels that they got an equal amount. But you can have advisory language that's not mandatory language. I'm more inclined to do that if I can. Less chance for family disharmony.
Nice, thank you. There was a question about what happens if someone does name the foundation, the United Methodist Foundation, as the beneficiary. So if you've gone through the process with John, or you've decided with another attorney or the beneficiary of your retirement account, whatever it might be, and you've decided that a portion of your estate, maybe a tithe or a child's portion, is going to go to charity, and you want to use us like John described, you let us know and we'll work with you to draft a donor-advised memorandum, which is mainly this fund agreement, giving us clarity and you confidence about us receiving, the United Methodist Foundation receiving the resource at the end of your life. You could start funding it earlier if you so desired, but most folk make that charitable gift at the end of life, and we'll invest it. We'll invest it in a long-term investment strategy, professionally managed, and then every year we'll make a distribution of that. A certain percentage of that is sustainable if it's set up to be a permanent fund. And then we'll decide of that 100% that we're making distributions, this is how much you want to go to your church, or this is how much you want to go to the college, or some other charitable cause. I'm going to share my screen with a graphic here. This comes from a flyer that we've made. And so once you've decided to do that and named I'll make up a term, named the Dustin Pets Endowment Fund, for example, and we've set up the agreement, my estate would make a distribution, and then we'll care for that, and we can make annual gifts to the different causes that you desire in the proportions that you set up. They need to be all 501c3s. We want half of it to be United Methodist related, but it doesn't have to all be United Methodist related. We could send contributions to a state university or some other entity. Maybe you want to support your church and a college, and maybe United Methodist Committee on Relief or some other thing. And then we'll administer that and make an annual gift to those causes in your endowment fund, your family fund's name, and be able to carry on your giving to those different causes and to make a lasting and significant difference for them to do their ministry. Sometimes we've had families make requests that go to a particular cause. So for instance, it's at a university, United Methodist school, and you wanted to fund scholarships, or you wanted to support a particular ministry, same kind of designations. My normal recommendation is to have, similar to what John just said for estate planning, is something like first preference for this kind of ministry, so that you can give some advisement, but it doesn't get locked in. I've been on the church side and found gifts that are hard to administer because the donor restrictions are so tight. But it's a great ministry that we provide. Half of the resources, the foundation, are used in this same capacity for the faithful gifts that have been given. Are there any other questions? I'm getting an alert that I got just a few minutes left. John, we're so thankful for your ministry with the United Methodist Foundation for these many decades, and also for your presentation today. If someone would like to meet with John and be a part of our process, if you'll let us know, we'd be honored to have that conversation. Or if you'd like to just talk about ways that we might serve you, it would be our great honor to help you give generously and help you to leave a lasting legacy with the resources you've been entrusted. Let me pray. Gracious God, pour out your Spirit upon us. Help us to trust you in the midst of life, to do all of our hard work of planning and preparing, so that what our resources that we have, the things we've invested in and we've cared for, and throughout the course of our lives, that we can make sure that they are used in ways that align with your kingdom and connect with our values. Help us to give the gift of a lifetime, and to push our values into the future with our family and with the charitable causes we care about. Help us to know that you are at work with us. We give you thanks in Jesus' name. Amen.